I'm Elizabeth Talbot with the Talbot Law Group in Walnut Creek, California, and I'm the Estate Plan Coordinator and Paralegal. So today I'm going to talk about how you get started with your estate plan. So generally at our office what we do is we try to make it as simple and easy and manageable for people to start their estate plan and of course complete it. So we do this using what's called the Estate Planning Questionnaire, and this just goes through the basic information of how you would like your estate plan to be done. So first you're just going to put your information and your spouse's information if it's a joint estate plan. And then we have you list who are your children. You may not have children, that's fine, you just don't put anything. Then we also have a section for additional information where you could put anything that you think might be relevant. One thing that could be a possibility to put here would be, do you wish someone to specifically be precluded from receiving your assets? The next thing would be to list your assets. So do you have a home, bank accounts, retirement accounts, just for informational purposes, anything that you would like to pass on to someone else when you pass away. So the next part after you list all your assets is you want to specify how you would like your assets distributed. So it might be to your children equally, and you might specify what ages you would like the assets distributed, or if it's not to children, what people you would like it divided amongst. Then we have another section which encompasses if all your beneficiaries are gone and none of them are going to receive your assets, who would you like to name before your assets go to heirs? Because that's kind of the default under California law, is that if there's no one designated to receive assets or everyone designated has already died, then your heirs are going to get your assets. So you may want to designate a charity or other specific family members to get your assets before it's given to heirs, in the rare case that your beneficiaries are totally gone. So then what's the next part of our questionnaire? That would be naming the trustees of the trust. So first, you're probably going to name yourself because you want to manage your own trust, and maybe your spouse if you have a spouse. So then you're going to specify who you want to be trustee after you're gone. So that could be, often it's a family member, sometimes it's a child, it just depends on your situation. It might be a professional fiduciary. Then you're going to specify who will be in all the other positions, such as executor, agent under the durable power of attorney, agent under the healthcare directive, and that kind of thing. So you're just going to name all the people you would like to appoint in the event of your death. And if you have minor children, that's also going to include appointing a guardian of your children. So that's the basic thing for how the questionnaire goes, how the questionnaire is done. And there's some additional questions regarding specifics of your advanced healthcare directive and living will. You know, would you like the plug pulled, that kind of thing. But those are the basics that you would fill out in the questionnaire, and then you would talk through it with the attorney and finalize all your choices, and then the estate plan can be put together for you and is ready for your review and signature. Thank you.